So Section 5 of the Voting Rights Act is the core of the Voting Rights Act. We think of it as the heart of the Voting Rights Act. It's one of the most important civil rights statutes ever passed. It's been a transformative act in the United States of America. It's so important because it's able to stop discrimination in voting before it happens. It requires parts of the country that have really intense histories of discrimination to submit all of their voting changes to make sure that they're not discriminating before they can take effect. If you take away this democracy checkpoint to shine the lights in the dark back rooms where people's rights are being trampled, what will happen is that minority voting rights in many places across the country will be threatened. We think it's completely unnecessary. Congress determined that it was very important to still have this act in place, and indeed supported it almost unanimously. And so the idea that after so many years we would not have a Voting Rights Act when it's so clear that we still need it really hurts our hearts. There are really two questions that are at the heart of this case, Shelby County v. Holder. One is, have we moved far enough past the discrimination in voting so that we don't need it anymore? The answer decidedly is no. Although we've made progress, it's possible to make progress but still have problems, and that's what we've seen. Progress, but still discrimination in voting. The second question is, okay, if there's still discrimination in voting, why are you going to have a law that focuses on some places and not others? And to that question we say, we have taken a careful examination to see where has the discrimination in voting manifested itself in a way that has been repetitive and adaptive. By that I mean that you have multiple discriminatory measures happening again and again, and that every time there's a case, there's a new way to try and achieve the same discriminatory end. This part of the Voting Rights Act has been very effective at pushing away that kind of discrimination. The law does not say that voting discrimination only happens in the places where this law operates. But what it does say is that the nature of the discrimination in some places has been different than it has occurred in other places. And because of that difference, we need a special answer. We need a special remedy. And that's why we have this part of the law targeted at some places but not others. I think the reason we see so many cases trying to take this statute down is because it's been so effective. There are those who would like to operate behind closed doors and in dark rooms without this important protection in place. The court has consistently, through the decades, rejected every constitutional challenge to this core provision of the Voting Rights Act. It's about Shelby, but it's about all those places that have this deep history of persisting discrimination, and it's about something else. It's about keeping our promise. The union can be more perfect, and the Voting Rights Act points us on that path.